Hey everyone, how are you? Good morning. Good, let's see who we have. Make sure your cameras are on. If you're watching on YouTube, I cannot see you, but let me know that you're there so I can help you out if you have any questions. And we got Celine, Romello, Nidia, Amy. Amy, where are you? Turkey Cheeks, come back. Felix, Benjamin, Fallon, Olga, Alondra, where are you? I see Lee, Elda, I need your camera on, and Vanessa. All right, cool. So make sure you guys have your cameras on so it counts towards your hours. Somebody just joined this. Join. All right, cool. So here's the thing. We got updated student portal. All the videos are there, except for this one will be after today's class. I will post it there, but all the videos up to chapter 11, they're already there. So as you know, this is a brand new book. I'm updating as we go. Tonight I have chapter 12, so after I do chapter 12, it will also be there. All right, guys? So if you have any questions, you want to do the class replays, just go to the student portal. Everything's there. Review pages. I'm sorry, the actual pages for the chapter that Celine was complaining about in the beginning. They're there. I got you. And there's review quizzes available. I did some of those with a class last night, and it was fun. It was a lot of fun last night. So anyway, all the resources are being updated. So till the end of the week, we should have most of the stuff there. Okay. Elda says, my camera isn't working, so I cannot turn it on. I don't know what is it with your camera, Elda. Like towards the end of the class, it turns on. During the beginning of the class, you don't want to see us. That's what it is. We don't want you to see you. That's what it is. I got you. All right. It's too early. You're still getting yourself ready. I got it. No problem. All right, but to count for your hours, you have to remember, if I don't see you, if Zoom doesn't record you, there'll be a problem there. So, Elda, make sure you figure that out for tomorrow's class, please. Have it all worked out. Fallon says, can I get to quizzes or Quizlets? To the quizzes, you should have access. So let's go here. Hey Zenaida, good morning. Yes, let's go here to sites. Okay, so Olga was asking about the quizzes. If it's quizzes for each chapter, you go right here to the student portal, and right below the video there's chapter pages and then review quizzes. You click here and it opens. This is not Quizlet, okay? So Fallon, I'm going to address you in a second. This was for Olga. This is not Quizlet. This is review quizzes for each chapter, so it's actually Q&A. So almost if you're practicing for the exam, but within each chapter. Quizlet operates a little different. Quizlet is it's like a like flashcards. Okay, it's like flashcards. So it shows this. You click on it. What is the devisee? It's a person named in the will to inherit real estate. It's more like flashcards. They do have games here. You can learn, you can write, you can spell, you can test yourself, you can play, match gravity, go live, and stuff like that. But that's not what you should do. A combination of both. Don't just stick to one or the other. This one helps you. Quizlet helps you to associate things. So like I said, right here you had devisee. What's this word? Well, it's somebody that's named in the will. Okay, so for immediate association, Quizlet will be the best for it. For you to test yourself, there's these review quizzes. Okay, and there's questions here. There's the answers. Pick one. So write on a piece of paper, what do you think the answer will be? Once you're done with all of them, so in this first chapter, there's only 7 questions. But once you're done with all of them, here are the answers. And also the page where these answers are located. Okay? So don't go to the answers. Test yourself honestly, you know. Make sure there's no distractions. You don't have the book open. You're actually giving it an honest try. That's the best way for you to learn. Then you look at the answers, and based on the answers, go to the book. Okay, I had this wrong. Let me see why I had it wrong. So you go to the page and figure out why you had it wrong. Okay? Very, very important. As far as Quizlets, you scroll down to course resources. You go up, and it says access our Quizlet. Once you click here, it gives you access to the Quizlet that I just created, which is this one right here. And in this Quizlet, there's it's divided into folders. So you have real estate math, you have terms and acronyms, you have New Jersey only, and you have the nationwide portion of it. Okay, sometimes I need to add you or accept you. So, well, I think I had seen you here already. I had accepted already. But if not, just go to the link again that I'm going to send you right now. If it's to Quizlet, it is in the student portal, but I'm sending it to you again right now, okay? Here you go. I just sent everybody the link. If you're not there, make sure you join because it's very helpful. Also, Zelina, you should have received an email last night. Let me know if you got an email from us. Okay, check it out because your request was already resolved. It could take a few days, but it was already resolved. Okay. All right, guys. When you click Quizlet, it takes you here. Fallon, let me know if you got it. We're able to get it? No. Send me a screenshot on WhatsApp so I see what you're getting. Send it to me, not to the group, okay? You don't know how to add me on WhatsApp? 908-418-8325. Save my number. All right, cool. So let's move forward. Fallon, I sent you the link right now. So let's move forward. What we have here, oh, Jackie already joined us. Great. Cameras on, everybody. Cameras on, cameras on. All right, so chapter 6. This is the only chapter we're going to do today, guys. Depending on how it goes, we'll break it into two. But it's the only chapter we're going to do today. It's a long chapter, a lot of information here. And some chapters are going to be like that, just one chapter, or we'll do 2 chapters a day. That's my goal. But this chapter and definitely chapter 11, these are chapters that take the whole session. I'll do part 1 and part 2. So it will look, when you go to your student portal, it will look like this. So you'll have National Agency, this is chapter 11, National Agency part 1, and then there's the second part right there. So divided into 2, everything else here is just one block. All right, but just to give you a heads up, we'll break this chapter into 2. Don't forget to, if you are by any chance referring people, if you want to make some cash, don't forget to click here and create your account. All right, and then there's a specific link that'll be given to you. If you share that link and people join through that link, you make 20% commission on it. Okay, so anything that people come through you, 20% commission right there. If you're interested in referring. If you're not, then it's fine. Nina can't join Zoom. Nina, send me a message on WhatsApp. I'll send you the link right now. 908-418-8325. We have less people than usual, so I assumed, and that's why I'm delaying a little bit too. I assumed that some people cannot join. So let's figure this out. Guys, if you have questions, drop the questions right now. Nina. Come on. I'm sorry, guys. I love technology, my favorite technology, but sometimes these little things. All right, Jackie, I do see you on YouTube. Thank you. All right. All right. So Nina, 3 minutes. I'm gonna move forward. Just let me know when you're up. Okay. All right, guys. So transferring and recording title to real estate. What are we talking about transferring and recording title? So when somebody sells, and I'm sorry about the delay, but when somebody sells a property, right? The title of the property needs to transfer to the new owner, right? So how do we do this? Usually, a deed of conveyance will transfer from one person to another, right? So you know how I like to give a preview of what we're going to talk about. So right here, the deed will transfer. A will, so this is while you're alive. A will is when you die. A will also transfer title to somebody else, okay? And finally, we have involuntary title transfers, like when you're forced, when there's a foreclosure, right? So involuntary title transfers, okay? All right, Nina, I just sent it to you. Click on the link. Hopefully bring you right in. All right. We're going to make Nina pay for lunch for everybody. No? I think it's fair for the delay. What do you think? All right. So, and then, so these three could be methods of transfer. So deed, the will, and involuntary transfers. And the transfer itself does not have to be recorded, right? But it's ideal that we have a title record. How do we have a title record? Not only it's the paper, but also putting it into public records where everybody can search. I think we talked about this briefly yesterday, right? Especially when we talked about who's first. We talked about taxes in the event of foreclosure, and then it's whoever recorded first. That's why title records are so important. By the way, Nina says, nope, not buying lunch. Messed up, I'm just saying. So let's start with legal and equitable title. So I already have a few things here which are very important. Do not write SFR until I explain what it is. So owning title to real property commonly connotes owning a complete bundle of rights. And we talked about the rights before, right? Romello, you were writing it as on the eagle thing, right? There was an image of the eagle and you told me to stop because you were trying to figure out what it was, right? The names? Okay, cool. So you remember those 5 rights. Can you guys tell me what are the bundle of rights that you own with? I just felt like Dora for a second. Can you guys tell me? So tell me the 5 rights. Write it down on the chat real quick. What are the 5 rights that we have? The 5 rights that we have when it comes to bundle of rights when owning a property. Okay, use is one of them. To sell, to exclude people. Perfect. So we got 3. What else? So we can use the property in any legal manner. We can dispose of the property that's selling. We can exclude people from the property. And we can enjoy the property or encumber the property because it's our property. We decide. So these two go kind of like together. It's what you can do with the property. Okay. Transfer goes with sale. So there's 5 rights. There's one missing. The most important one you guys still did not mention. The most important one. Aha. Possession. Okay, the first right you have is right of possession. It's your property. So that's your first bundle of rights. You can take possession of the property. You can use the property in any legal manner. You can enjoy the property because it's yours. So you can do whatever you want. You want to encumber it? Encumber it. You want to like put a mortgage. You want to do work on the property? It's yours. Do what you want. You have the right of exclusion. You can exclude people from coming in, block them from coming in. It's your property. All right? And you have the right of dispossession or alienation, which is being able to sell or gift the property. These are your 5 fundamental rights that come with the property. Okay? All right, guys. Laundry, make sure you have your camera on. Guys, get your camera on, please. All right. Cool. So, 5 rights. We cover that. And it says right here, that more accurately, someone who possesses all interests owns legal title to the property. And legal title is distinct from equitable title. There's 2 words here. Legal title is when you're the owner of record. Okay? That means your name is on the deed. That's your legal title. Equitable title means I've put money into the property, some type of nominal consideration into the property. So you have legal title, my name's there, it's mine. Equitable title, I have an interest in the property somehow. Okay? So let's consider, and I have right here, let's consider during the contractual period. So when we put an offer on a property and the seller accepts the offer, technically, the property is now mine. Why? I control it through what's called equitable title. I put $1,000 as a nominal fee to start the transaction. You accepted the transaction, right? So offer, acceptance, you accepted the transaction, right? So after returning review, we went back and forth and everybody agreed to the terms of the contract, so mutual assent, and it starts. The actual process, the under contract status starts then. So here's what we're saying. Because I put money into it, I have equity, right? Or monetary interest in the property. I have equity into the property. Can the seller sell if we're under contract? Sell to somebody else if we're under contract? No, they can't. You got it? I have control. I put the offer, the seller accepted, I have control of the property until closing. Okay, until the closing, the property is controlled by me. The seller cannot sell to anybody else. Okay, again, it's still your property, seller. Okay, let's say you're the seller. It's still your property, right? But you're now limited on what you can do with it. Legal title, it's a seller's. Equitable title, mine. Or a lender as well. So it's very important you guys understand these 2 differences between legal and equitable title. All right, we're going to go to the next page. So ownership of legal title is a function of evidence, and the court will generally rule that the person who has the preponderance of evidence of ownership is the owner of the property. An example, if the first 2 buyers did not receive a deed while the third party did, the third party may have the best evidence and be ruled as a legal title holder. However, what if the first buyer had moved into the house and occupied the house for 6 months before the original owner actually sold the property to the second and third buyers? And what if the second buyer, after searching records, reports that the seller never really owned the property and therefore could not legally sell it to anyone? Now, who owns the property? Okay, so you got a little confused, right? Because the seller can sell to as many people as they want. The question is, who owns the property if I sell it to 3 or 4 different people? So the illustration underscores the difficulty of proving title. It's very difficult to prove title to real estate. There's no absolute or irrefutable proof that the party holds legal title. Our legal system has developed 2 forms of title evidence: actual notice and constructive notice to assist with determination. So let's go to actual notice. And this one's very easy. This is the easiest one of these two. Between actual and constructive, very easy. Ready? Actual notice means you actually know something. Simple as that. Before you took the class, you knew the class existed, but you did not know the details of the class. Now you're in the class. You have actual notice. You have actual knowledge. So notice is knowledge. You have actual knowledge. You got it? Actual notice means actual knowledge. You know about something. You have a direct experience or communication. So when you pull the public records of a property and you see there's a mortgage in 1998, there's a mortgage in 2000, there's a tax lien, there's a water lien, there's a construction lien, all this stuff that's going to be on record, you know it because you search public records. So now, or you did a title search, so now you have actual notice. And this is different from constructive notice. Now, what is constructive notice? Let me show you something real quick. This is my whiteboard, right? And now what I'm going to do temporarily, guys, I'm going to write something here. I'm going to start writing something here. But I'm going to switch the screen for a second. And I'm writing something. Okay? I'm going to go back to the book. Where's the whiteboard? It's not here, right? It's not on the screen. But you guys know that I wrote something on it, right? Okay. So imagine that whiteboard. I'm going to show you what's there in a second. Imagine the whiteboard as being public records. There's something written there. The information is available. All you have to do is ask or research. The fact that the information is available is called constructive notice. You guys already know that I have something in public records somewhere, right? That's constructive notice. It's something that anybody could have or should have obtained. How do you get there? How do you guys get to see what's on the whiteboard? Anybody? Let me know. Let me know in the chat. How do you get to see what's on the whiteboard? Simplest. Ask. Go to the Hall of Records. Yes. Ask for it. Ask, and you shall receive. You guys now have, because you asked, you now have actual notice of what I wrote down. You see the difference? All right? So, this is whether you understand my handwriting or not, but it's there. Now you know what it is. So, Romello, make sure you click to everyone, not private. Thank you. So, you ask for it. You research it. Until this was presented to you, it was constructive notice. It was available. All you needed to do was ask. So you can go to a title company and say, hey, title company, I need a title search on property 123 Main Street, whatever. Okay, and they pull a title search for you. Once you receive the title search, it says, hey, this is a real estate class. This was your search right here. Boom. You guys got it? Thumbs up. Great. You need to know the difference between actual notice and constructive notice. It will be addressed later on as well. And there might be a few questions in the state exam as well. All right, so again, the foremost method of imparting constructive notice is by recordation of ownership, so putting into public records, specifically title records. Now, since public records are open to everyone, the law generally presumes that when the evidence of ownership is recorded, then the public at large, so everyone, has received constructive notice of ownership. Can I find out who owns your property? Yeah. Where do I go? Public records and ask for the title records. Simple. You're telling me you own it? Let's verify it. It's as simple as that, guys. Difference between actual notice and constructive notice is what you know or what's available, and you should have known. Okay. Transfer of title. What's another word, guys? What's another word for transfer of title? What is another word for transfer of title? Anybody? Let me know in the chat. Another word for transfer. Very good, Felix. And Nina? Conveyance. Conveyance, transfer, transfer, conveyance. Guys, transfer of title is a conveyance of title. So transfer of title to real estate is also called alienation. Now this word you guys are going to see a bunch of times. Alienation. Why? Why do we call it alienation? What is alienation? Why is transfer of title alienation? Let's look at the word alien. Who can tell me what alien means? Let me know. What does alien mean? The word alien. Olga says name. Zillian says foreign. Nina says foreign. Felix says foreigner. That's right. Foreigner. Outsider. Okay? That's what it is. So, if you guys think about this, who has legal title to the property? The owner. Right? We just talked about legal title and equitable title, right? The owner has legal title to the property. If a buyer comes along and puts an offer, who is the buyer? The buyer is a foreigner to the title, right? Nobody knows the buyer yet. He's a foreigner, therefore an alien. All right, and let's think about it this way. Let's go to immigration for a second. If you come into this country, right? If you come into this, or any country, if you immigrate, right? If you go to another country, you are an alien to that country because you were born somewhere else. You're an alien. Now, there's different steps. You can become a legal alien, or you can become a naturalized citizen, right? So you can become a citizen of that particular country. When you are the owner of record of a property, you are like the citizen or the legal resident of the property. Does that make sense? Yes? If you don't own the property, or if your name is not on the title of the property, you are a foreigner. You are an alien. So therefore, the transfer of properties, alienation, is giving it to somebody that was not of the property. You guys got it? Giving documents to somebody, transferring documents to somebody, and making them now a citizen of that particular property. The best explanation I can find, so hope it helps. So, the transfer of title, also called alienation, occurs voluntary or involuntary. When the transfer uses a written instrument, the transfer is called a conveyance. Now, the word instrument, the example is the deed. Deed is the instrument that transfers. The word instrument in this scenario for public records is called document. So every time you see the word instrument in real estate, we're talking about documents. It could be a musical instrument, right? That's what we use to play music. It could be a surgical instrument. That's what we use to perform surgeries. In this case, what we use to put stuff into public records or to acknowledge the transfers is called a document. That's the instrument used. You guys got it? All right, good. All right, transferring title to real estate, there's two ways, like I said, voluntary and involuntary. Voluntary, we already covered this yesterday, that means you want to. You want to transfer. Involuntary, you're being forced to transfer. That's what these words are, right? How can you voluntarily transfer property? By public grant, that means you're offering it to the city, for example. By deed, that means you're alive and you're transferring the property, willingly transfer the property to somebody else. And then by will, that means you died, but you left in your will that you wanted to transfer to a particular party. Okay, whether it's your immediate heirs or it's somebody else that you designated or a corporation, but that's by will. It's your will, so it's voluntary, right? Involuntary transfers, we have descent. The law of descent and distribution means you died without having a will. So the government keeps your property by what's called escheat. So they cheat you out of your property for not preparing a will. There's more to this. Foreclosure. The word foreclosure means you did not pay your bill, like you have a financing against the property or taxes or whatever, and they can resort to foreclosure. So they can take you to court and take your property away. Eminent domain. Eminent domain, as we spoke about briefly yesterday, is where one of the government powers to take over your property, to take the property from you, right, for public good. So the government wants to build a school, right? They need your house, the house next door, and a couple of other houses to knock them down and build a school in that particular area. So they're going to take the property from you, give you some money for you to walk away, right? They call it fair compensation. Most people don't think it's fair, but that's at least you get some money. Adverse possession, it's involuntary. If you guys remember, adverse possession is where somebody takes over somebody else's property. You guys remember that? Great. And then we have estoppel. Estoppel is where you're seized. Lee remembers that. I will tell you about the 2-year takeover instead of the 20-year. I will. So estoppel is where, as the name says, it stops you from being able to do something at one point, okay? So the word is estoppel. I'll go over that in a little bit. So you guys already got it. Voluntary is unforced transfer. Involuntary is without consent. We got this. There's different deeds of conveyance, guys. Different deeds of transfer. What is a deed? It's a document that transfers the ownership from the grantor to the grantee, from the seller to the buyer. Okay, so that's a deed. There must be, and we'll talk about all this, there must be a delivery and acceptance. Because guys, I can offer you whatever I want. I can offer you anything. If you don't accept, is it valid, my offer? No. So everything in contract, in law, must have a delivery and acceptance in order to be valid. So we're going to talk about different types of validities as well. There are also deed clauses and covenants. You guys remember, I can restrict what you can do with your property, right? Remember when I sold the property, we're going to use Romello again, like yesterday. I sold the property to Romello as long as he's alive. Well, that's a clause or a covenant or a restriction in the deed placed by a private party, okay? Statutory deeds, we're going to go over them as well. Special purpose deeds and transfer tax, all right? But those were the main ones. Delivery and acceptance. Like I said, the deed is the legal instrument or document used by the owner or the seller, the grantor, to transfer title voluntarily to another party, the grantee, the buyer. Execution. This is not my signature, by the way. Execution of a valid deed in itself does not convey title. So for me, just, that's what I was showing you right here. For me, just preparing the deed that say that I will transfer to Benjamin, okay, to Benjamin, I'm going to transfer property to you, okay? I'm going to sign it, okay? I'm going to sign it. Just by preparing it, it's not enough. It's like I told you. If I offer and you don't accept, if you don't take it, it's not valid. So I can prepare as many documents as I want. I can sign as many documents. If you don't accept the terms, it's not valid, okay? So it says right here, it is necessary, it's in green, so it's very, very important. It is necessary for the deeds to be delivered to and accepted by the grantee, the buyer, in order for the title to pass, all right? To be legally valid, delivery of the deed requires that the grantor be competent at the time of delivery. So I'm aware of what I'm doing, right? So I'm a legal adult and of sound mind, and intends to deliver the deed beyond the act of making a physical delivery. Because I can also give you a paper, but then prepare a paper and give it to somebody else, right? That doesn't mean I had the real intentions. So not only do I give you a paper, I also really want to transfer it to you. Validity of the grantee's acceptance requires only that the grantee have physical possession of the deed or record the deed. Right here, I want to address something. Where it says record the deed, not every state requires a deed to be recorded. State of New Jersey, for instance, does not require. So you accepting the deed, having it in your hand, is more than enough to prove that you are the owner. It's just that by recording it, by putting it into public records, it's the one extra step to say, hey, I'm here, I'm the owner, this is my property, nobody can do anything about it, it's mine. Does that make sense? So the reason why we record is pretty much to put the flag down and say, I was here first, right? Well, isn't that what they used to do back in the days? Medieval times, they would conquer certain areas and put the flag and say, hey, I was the first one here. And once the flag is there, nobody can claim it. They can take over, right? They can fight and take over, but nobody can claim it. Nina's asking, you don't need to sign it as well? Well, the grantor needs it. The grantee doesn't. The deeds are signed only by the grantor. Now, once accepted, title passes to the grantee, right? And the deed has fulfilled its legal purpose. The deed has fulfilled its legal purpose, and it cannot be used again to transfer the property. If the grantee loses the deed, there is no effect on the grantee's title to the estate because you had already accepted it. The grantor, for example, cannot reclaim the estate on the grounds that the grantee has lost the deed after it was delivered in acceptance. So, I gave you this, right? The mouse. You lose the mouse. Can I go say, hey, give me the mouse back because you lost it? No. So that's what we're saying right here. Once the deed is passed along to the buyer, that's it. I'm seized of the property, meaning I no longer have possession of the property. I have to walk away. I no longer have any rights on the property. I have to walk away. The property is now yours. What you do with the document or not, that's up to you. I transferred, it's yours. All right? Nor can the grantee return the property by returning the deed. To do so, the grantee would need to execute a new deed. Now, in states, they use the Torrens system. We'll talk about it in a different time. The state that uses the Torrens system, the title passes only when the deed has been registered on the certificate of title and the transfer certificate has been issued to the new owner. What is a certificate of title, and what do you mean registered on the certificate? Anybody has a car? You got a car? Raise your hand if you got a car. Okay. Have you ever seen the pink slip? All right, you know what a pink slip is, right? All right. So the pink slip, if you have it financed, probably not, but if you already paid it off or if you've had it in the past, right? There's a pink slip, and that slip on one side says title. On the other side, it says bill of sale. Okay? So what we're saying here is that this is very simple. Until there's a certificate of title issued and registered for the property that shows, okay, certificate of title, it's good title, right? And the transfer has been registered with it, the deed. Until this occurs, it's not valid. So only a few states actually use the Torrens system or a mix, but that's what it is. You're going to have a certificate of title that says the property is yours, similar to the car certificates. Depending on the state law, so Nina, to address what you asked before, depending on the state law, a deed must meet the following requirements for validity. The deed must be delivered and accepted. We got that out of the way. We know this. Have a competent grantor and a legitimate grantee. Remember, because the grantor is the one signing, because the grantor is the one preparing it, they must be competent. Legitimate, that means we're appointing the right person. Because I can sell my property to my son. My son is 14 years old. I can transfer it to him. I'm a competent grantor. He's a minor. Doesn't understand the thing about real estate. But I just have to name the grantee so you know exactly who the owner is. Does that make sense? So the grantor is the one that prepares the contract, is the one that must be the competent party. The grantor must be living, of legal age, and mentally competent. If the grantor is a corporation, the signing party must be a duly authorized agent, and the grantee must be living or have legal existence, but does not need to be of legal age or mentally competent, as I said. It must be in writing. It must contain a legal description. We'll talk about that in chapter 9. It must contain a granting clause. That means I grant this property, or the rights that come with it, I grant to you, the buyer, right, the grantee. It must include consideration. What does the word consideration mean? Exchange of value. So the deed must clearly state what the exchange was. I gave you a house. What did you give me? You gave me money. You gave me a car. You gave me another house. You gave me other assets. There has to be an exchange, a nominal fee or consideration. Okay, so I'll give you this in exchange for that. You guys got it? Every time you see the word consideration, think of exchange for value or money. Okay? So the deed must be accompanied by valuable or monetary consideration or good consideration, which will be, for instance, love and affection. Like me giving a property to my son, my minor son, right? The valuable consideration was love and affection. There was no money exchanged, right? But there's love and affection. That's why I gave him a property. Okay? Also a bribe, hopefully, hoping that my kids will take care of me when I'm older. So it's like love and affection, you see? Anyway, the next thing, in New Jersey, for instance, and a lot of states, says that the amount does not need to reflect the actual price. In a lot of states, the actual price must be stated. So you need to know, again, what is your state law? We'll talk about that in the final week of this course. But your state law, for instance, New Jersey, you must state the actual price. So if you sold it for $300,000, then $300,000 must be on the deed. You cannot put $1. Okay? You guys got it? All right. Nina? The deed must be signed by the grantor. The deed must be signed by the grantor, but need not be signed by the grantee. Okay? So who prepares and who's giving it? The seller, the grantor. So I'm the one that has to describe what I'm transferring to you. It's the mouse. Right? Think about it this way. When you go to the supermarket, you're buying stuff and they give you a receipt, right? Do you have to prepare that receipt? No, the seller does. The supermarket does. So it's on them to have these things like signatures or anything else like that. It's on the seller. You just receive it and walk with your stuff. You walk away. Pretty much the same concept here. You don't prepare anything, you just get your receipt. Think of the deed as your receipt. Okay? So it does not need to be signed by the grantee unless the deed contains special provisions that require grantee's acceptance. Grantors may also give power of attorney to other parties, authorizing them to execute deeds on their behalf. Okay? The power of attorney authorization should be recorded to ensure valid conveyance. So, I want to address this real quick, the power of attorney thing. Let's say you're handling a customer. Right now, you have a buyer or you have a seller, and there's a closing tomorrow that we've been waiting for the past 3 weeks. But the seller already had a vacation booked for this week. So if the seller's not present, how can we close? Well, we can appoint a third party. We can appoint somebody else that will be given power of attorney, meaning representing somebody else, right? Power of attorney is representing the seller in this case. And they will be signing the document or recording the document on your behalf. You guys understand? So power of attorney means you're appointing somebody else to do something for you. It does not need to be signed by the seller. It needs to be signed by the seller or a power of attorney. Somebody appointed, legally appointed. And by the way, when it says power of attorney, if you guys never heard this word before or don't understand it, it does not have to be an attorney. It's literally me saying, let's see, Felix, I'm going away tomorrow. There's a closing. Could you please sign it for me? And if Felix says yes, okay, I'll prepare a power of attorney. And Felix, not an attorney, right? You're not an attorney, Felix? You're not an attorney? Or are you? No? Okay, so Felix is not an attorney. Simple. But he'll advocate for me. He will do something for me. That's what it is. Okay? It also must be acknowledged. We already covered this. The grantors must declare before a notary or other authorized person that the grantor's identity and signature are genuine. So every time you hear the word acknowledgement, it's a declaration that the grantor or the person signing is the person that's entitled to do so, and their signature verifies it. Pretty much that's what it is. Okay, so notarizing or being acknowledged is having somebody recognizing that you are who you say you are. That's all it is. Okay? And look at this one. A lot of people don't understand this. That's why I have it here in green, because there might be a question in a state exam where it says it involves 2 or 3 parties, where the seller gave the deeds to 2 different parties. Okay? So if the seller deeds to his grandson, for instance, but forgets to give the deed, and then a couple of years later sells the property to John, right? And John accepts it and goes record it, who owns the property? Does the grandson have any rights in the property? So here's the thing. Just because John recorded, that's not what was necessary to make the deed valid. How do we make the deed valid? Acceptance. In this case, in my example, John accepted and recorded, while the grandson didn't even have it. He found the deed later on in the safe or whatever when his grandfather passed away. Are you guys understanding? So it's delivery and acceptance that actually makes the deed valid. It's not the recording act that makes it valid. Remember this for state exam. It's almost guaranteed you're going to have a question like that. The recording just proves again, my flag, I'm here, I'm entitled. That's pretty much what recording does. It does not prove that it's valid. It just proves that it puts you first in time, first in line. That's all it is. All right. Conveyance clauses, it's transfer clauses. What are you transferred? The granting clause is the only one that's required, not these ones. It's the only one that's a required clause that says, I am transferring you or granting you the rights to this property. That's what it is. It explains who the grantor, who the grantee is, what the property is, what was the consideration, and make the transfer actually valid. So it's the granting clause. The habendum clause describes the type of estate being conveyed. If it's a fee simple, life estate, or whatever, and to have and to hold, these are the powers that you get with the property. The redendum or reserving clause, it's pretty much the deed restrictions and limitations. If you guys remember, right? The property sold as long as, or there's certain things in the title that, or easements or rights that have to be reserved with it. Right? Tenendum clause just identifies the property that's being transferred with the land. So there's land, and then there's other property that might be transferred with it. Okay? I don't have these highlighted because most likely it's not even going to be a question on the exam, but you still need to know. You still need to know these basics, okay? There's other clauses. We have covenant or warrant clause. Covenant or warrant clause. A covenant is a promise. A covenant is a guarantee. So I promise you, I warrant, I assure you, that's what it is. That, this, or that, whatever the clauses are. So we're going to go over these clauses. Depending on the type of deed, you can find one or more of these clauses. The first one is warranty of season. Pretty much what it says is, I own the property, and I have the right to sell to you. It makes sense, right? Right? If I have this mouse right here, and I'm selling it to you, that means I own it, right? What do you think, guys? Let's address that question right there. I'm telling you, whoa, that's a big question. You've been typing it since like what, 10 o'clock? All right, hold on. Let me finish what I was saying. I'll come back to your question. So what I was asking is, I have this in my hand and I'm going to sell it to you. Does this mean that I'm the owner of the mouse? Let me know in the chat. I'll come back to this in a second. Come on, guys. Give me answers. A lot of no's. Question again, please. I charge for repeating questions. So, all I was saying, this is in my hand. And I'm telling you, Felix, I'm going to sell you a mouse. This is a great mouse, best mouse. It's my mouse, but I'm selling it to you. Does it mean that I'm the owner? Great concept, but that's not what I'm getting at. But that's a great concept. The question is, am I entitled to, if I'm selling it, that means I'm entitled. If I'm entitled, that means I'm the owner. That's what I'm asking. Or can I sell somebody else's property? You see what I'm trying to get at? There's a lot of times that people, especially when it comes to fraud, that people sell something that's not theirs. Okay? That could be fraud. I cannot sell something that doesn't belong to me. I mean, I can, right? But I shouldn't because there's legal complications that come with it. So in this case, I'm giving you, Nina, I did not forget, but in this case, I'm giving you a guarantee or assuring you that I am the owner. Don't worry about it. I am the owner and I have the right to sell you this mouse. Okay? I'm sorry, house. So I have the right to sell it to you. Okay? The warrant of quiet enjoyment. So we move forward from that one and you'll understand here. The warrant of quiet enjoyment. I'm guaranteeing you, I warrant. I guarantee you, I assure you that you, the buyer, will not be disturbed by a third party that disputes the title. Okay? So that's what I'm telling you. I warrant or I guarantee that this is my mouse and you can keep it, and nobody is going to come and dispute the fact that this mouse is yours or not. Right? I'm the only one that can actually transfer to you. All right, guys, understand this? These are the two like basic warranties or guarantees. I own it. I have the right to transfer, and don't worry about it. There's no third party that will come and say, well, that was my mouse. Bruno could not have sold it. All right? So think about it this way. This is a trade, a tool of the trade. So it belongs to the business. So technically, the school owns the mouse. If the school owns a mouse and the school is a partnership, can I just say, hey, here's the mouse, I'm selling it to you? Or should I consult with the other party and agree to sell it? Both of us agree to sell it. Are you guys understanding? So between the warrant of season and the warrant of quiet enjoyment, this should go hand in hand, which is I'm selling it to you, and don't worry, nobody will dispute it later. Pretty much that's the first guarantee. All right, before I move forward, we had a book to read. Give me a second. Go read this book. What was the question right here? So, does the conveyance have to be, or transfer have to happen face to face? Because what happens if it gets lost in the mail? Does the grantor figure you got the deed and the transfer occurred, but you don't know the deed was sent since you never got it? Does there need to be a verbal exchange to ensure the transfer happened? Okay. So I cannot just mail you something and, hey, here's your property. We had to have a mutual agreement. So this will definitely go with it. Has to. There's a mutual agreement. Nina, I'm transferring something to you and I'm sending you the paperwork in the mail. Okay, that could be the scenario. Nowadays, the way things work, and these are valid questions, but nowadays the way things work is we have closing agents. It could be the attorney, it could be a title company, right? So does it have to happen face to face? We're moving everything towards e-signatures, right? We're moving everything towards electronic, towards virtual and all that stuff. And COVID, whether you guys like it or not, and I'm not talking about the lives lost or anything like that, but COVID came to change something that needed to be changed a long time ago, which is accepting that we now live in a virtual world and our lives are so fast paced that nobody has time to go sit down for hours waiting for a closing, as an example. So this whole COVID thing helped in a lot of ways. There's a lot of drawbacks. Again, I'm not talking about lives, I'm not talking about health, I'm talking about business and daily activities, okay? So it helped transition where we needed to be. So with that being said, do these need to happen face to face? In case you guys don't know, there's a lot of transactions, and the number is growing ridiculously. A lot of transactions where the buyer hasn't even met the seller. We close without even knowing who the seller was. We buy, we sell without the seller even knowing who the buyer was. They know them by name, by paper, but no visual. So again, going back to this one, does it have to be face to face? Not anymore, but there has to be an agreement. Through these third parties, the attorneys or the title company, through these third parties, we have what's called an implied agreement. Okay? So with an implied agreement, there's an implied acceptance. My attorney, through my signature, received my granting of the property. Your attorney, through implied acceptance, received the deed. So if your attorney received it, Nina, you received it. Does that make sense? Title companies and attorneys record into public records. Whoever effectuates the closing, they record the deed. So a lot of times the deed doesn't even come to our hands. It goes straight to public records. Will you get a copy of it? Absolutely. But you don't get the original. The original was transferred immediately to public records. You see where we're getting at? And to avoid things getting lost, That's why you want to have the actual acceptance. That would be the ideal in the actual recording, whether it's you directly or the third party attorney or title company. But actual acceptance, very, very important. All right, guys. Any other question? Like one question, not 10 questions in one, that you would like to put here? That was a very good question, Nina, though. Questions, though. All right, no questions. So let's finish these warranties, and then we're going to take a quick break. Is that a deal? Yep. So, warranty of further assurance. Warranty of further assurance. I guaranteed that I was the owner and I could transfer. I guaranteed that nobody else is going to claim the title, right? So you're safe. And I further assure that if at any time in the future you need any help clearing any title problems, come back to me. I'll help you. I'll figure out what needs to be figured out. Just come back to me. I guarantee you that I will help you do that. Okay? But wait, further assurance, what is this one then? How much more can we guarantee? I'm also guaranteeing forever. What am I guaranteeing forever? If any of these things fail at any time in the future, again, come back to me. You don't have to defend the title. I will assist you in that again. All right? So think about this one right here. All of them, but especially this one right here. Think about it when you buy a car. Let's say you buy a brand new car, guys. Right? 2021 cars, they're already out, even though the year is not here, but 2021, that's what it is. And you buy a brand new car. It comes with a 10-year warranty. That means that until 2031, that car has a warranty. The average American switches cars on like after 3 years, 4 years, because now the whole leasing and even financing, you just switch cars, because that's when it starts getting problems. Okay, so if after 3 years of owning the car, we're in 2023 or 2024, and you decide to sell the car to somebody else, what happens to the warranty, the manufacturer's warranty? Does it stay with you, or it transfers also to the new owner? The warranty, let me know. What happens to the manufacturer's warranty when somebody buys a car that's only 3 years old and the warranty is for 10 years? It transfers to the new owner. Correct. So until the 10 years lapse, very good. Until the 10 years lapse, the warranty is in effect. It doesn't matter how many owners it has. The warranty is in effect. So if I warrant, as I'm selling the property, I'm selling the property to Nydia. If I warrant forever, Nydia, you can sell to Benjamin. Benjamin, you can sell to Amy. Amy, you can sell to Olga. And Olga's trying to sell to Lee, but then here comes the grandson. And the grandson actually has the deed that I had transferred to him and completely forgot, right? So, Olga, you cannot transfer to Lee because now you're in a lawsuit. You understand? You're a lawsuit for who actually owns the property. Who was entitled to transfer the property. I gave the warranty to Nydia when I sold it to her, but she sold to other people. The warranty transfers as well. So again, I will assist the grantee because the lawsuit is going to trickle down all the way up to Nydia. But I assist you guys in defending any claims to the contrary. I warrant it forever. If 100 years later there's an issue, if I'm alive, I still have the warranty. Okay? Warranty of encumbrances. It assures that there's no encumbrances on the property except those expressly named. If you guys remember the word encumbrance, it means cloud. It means limitations on the property. The encumbrance could be a lien, or it could be a physical or usage encumbrance. We talked about easement by necessity. We talked about adverse possession or easement by prescription. We talked about easements in gross and easement appurtenant. Do you guys remember these? Right? You remember these? Say yes. Nod your head. Okay, good. Even if you don't, just agree with me, and we're great. So, but these are encumbrances. If it's a shared driveway, I'm letting you know, hey, you only own half of the driveway. So it's expressly named as an encumbrance that goes with the property. You guys got it? Right? So that's the restrictions will be there. Felix, I got you. I see a question coming through. All right, Felix is Nina version 2, 2.0. I see him typing for a long time. Take your time. Until midnight, we're good. Don't worry. I'll check my calls meanwhile, and I'll go back to you. For those of you on YouTube, if you're wondering what's happening, Felix is typing for the past half hour. We'll get there to the question. Alondra. Yep, I can see you. What's up with you guys in the masks on while on camera? Like, you're far away. I feel like I'm training ninjas. You know? Nina, you're definitely a ninja. Got it fully covered. Right? Really? I was joking when I said Nina version 2.0. Guys, limit this to like a one-line question. All right, so let's see what's here. So it says here, if when the transfer gets to Olga, for example, and then the grandson steps in with the deed, giving that the warranty forever is still in place, does Olga get to call the first owner who is sure? That's what I was actually telling you. It trickles all the way up to whoever gave the warranty. So just like the car, if the car breaks down later on, where do you go? You're going to go to the dealership, right? Why? Because the warranty is from the manufacturer, the person that created the warranty, or the entity that created the warranty. So Olga, even though I did not sell to Olga, I sell to Nydia. Olga is going to have to sue Amy, Benjamin, going to have to sue Nydia, and Nydia says, wait a minute, it wasn't me, it was Bruno. So adds me to the lawsuit as well. So it goes all the way up to the original. The people after me, so after Nydia, it was Nydia, Benjamin, Amy, and then Olga, will excuse themselves from the lawsuit. Well, Olga has possession, so she has to stay. But the other ones will exclude themselves from the lawsuit because, hey, I didn't give no warranty, right? So if you buy a car from me, I'm private. I'm not BMW, I'm not Mercedes, I'm not Hyundai, I'm not Kia, none of those. I'm a private entity. I own a car and I transfer to you. If the car breaks down while in the warranty, Felix, are you going to come to me and say, hey, Bruno, you sold me a car that broke down? Well, it's under the warranty, man. Go to the dealer. If I sold you the car after the warranty and the issue occurred and I was responsible for it, yeah, come to me. Other than that, it was under the warranty. Go for it. Does that make sense? So you bypass me and go to whoever gave the warranty. The scenario here is exactly the same. Cool? Great. I feel like I have to do it. Hold on a second. All right, so next step. Where were we? I got 3 people with masks. Might as well. I get it as well. Can you guys hear me? Great. So that's what we're doing. All right, the next warranty or guarantee, guys, right here. It's the warranty against grantors' acts. This right here is the most common warranty to go with the property, along with these two, the quiet enjoyment and warranty of season. A warranty against grantors' acts says, hey, while I had the property, while I had it, I've done nothing to encumber the property, meaning I've done nothing to damage the property. So I'm transferring it to you based on my knowledge of what I've done. I don't warrant the future or guarantee the future, and I don't warrant the past or guarantee the past. Does that make sense? Pretty much it says, you can come after me if something happens, but I can only guarantee what I did. Simple as that. And this one makes more sense than the other ones, right? Warranting forever in the past and stuff like that. Crazy. There's different types of deeds. We have a bargain and sale deed. Pretty much a bargain and sale deed is where we bargain, we negotiated, and I sold the property to you. So bargain and sale, simple terms, right? So bargain and sale deed is the basic one. In a straight bargain and sale deed, the covenant is I own, but I won't defend. What does this mean? In a bargain and sale deed, the grantor covenants that the title is valid, but may or may not warrant against encumbrances or promise to defend against claims by other parties. If there is a warranty of defense, the deed is a full warranty bargain and sale deed. So, hey, I own it. I don't guarantee anything else that might have happened against the property. That's the only thing I guarantee. A general warranty or full warranty deed, right, is where we put all those warranties that I said earlier. We put them all into the deed. This contains the fullest possible assurance of good title, and it's the best protection to the grantee, the buyer. So technically, anything happens, come to me. I'm liable for defending or reimbursing you for any damages that you might that might occur during your ownership. So I own it, and I'll defend anything. The special or limited warranty deed, it's pretty much the one that I said, covenants against grantors' acts, right? I guarantee that while I had it, this is what I've done. Beyond that, I have no idea what could happen. So it says, a special warranty or limited warranty, I own the property, and I will defend against my acts only, things that I've done. You got it? If something is incorrect in what I'm telling you, sue me based on what I've done, not based on the previous owner or future owners. And then we have this one, quitclaim deed. Okay. I divided it into two for a reason. To be easier to remember. Quitting claims to the property. Here's an example. I own the property 100%. Okay? Right here, say Bruno. I own the property 100% ownership. A few years later, I decide to get married. Good question. When people get married, what does the spouse usually say, or one spouse says to the other? What does usually happen? Hey, we're together in this, right? So let's join forces. Something like that, right? So what happens when we're married? We now share. For the title to pass to both, right? It was just me, but for the title to pass to both, I must now quit claim to 50% ownership to the spouse. and I keep claim to the other 50%. You guys got it? I was 100% owner, and now I'm quitting claim to 50% to the spouse. So I'm giving up, I'm giving up 50% of the claim or ownership title to somebody else. I'm adding somebody else, quitting claim. Whether it's 10%, 20%, 50% is by agreement. But in this case, we're married. That was our decision, 50-50. All right? And then later on, continuing the timeline, there's a divorce. As an example, there's a divorce. What happens in the divorce? I now quit claim to the remaining 50%, making the spouse 100, or the ex-spouse 100% owner. The point here was, I own something 100%. The moment I share with you whatever I have, I'm quitting full claim to the property and giving up part of it to you. You guys understand? Later on, if that changes, I lose it all, or you transfer back to me, whatever happens, it's still considered a quit claim. I'm quitting claims or rights or benefits to a percentage or the whole thing. So part of a percentage or the whole thing that I own or you own or vice versa. Okay? You guys got it? Quit claim, you good? So when you see the word quit claim, literally is giving up something. You're quitting claims to something. Okay, 3 lines less than what before. Wait, what happens with everything you own once you get married? Automatically 50-50, or our docs sign which make the 50-50 ownership happen? So remember dower and courtesy. It depends on which state you're at. There's homestead, dower and courtesy, or legal claims that could happen. Depending on the state you're at, automatically what you own is 50-50 unless you separated the assets by a document to either join or separate or determine a prenuptial agreement, or determine in the future, if we ever get divorced, this is what you get, this is what I get. So most states, automatically, we share. We're married, we share. Right? But all the states have the ability of you preparing a document that says, I really love you, but in the future, we never know, right? We change, people change. So I love you now. So in the future, if we, don't love each other anymore, I keep whatever I had, or whatever we acquired together, we split 50-50. That's it. We're pre-divorcing. That's what it is. In case it happens, but don't worry, I still love you. That's what that document is. Unfortunately, sarcastically as I was, or ironic as I was right now, it's a double-edged sword, because if you love somebody and then you demand a prenup, you're really setting yourself up for that divorce. So what do you mean? Like, you intend on getting divorced? So you could fire back on you. But then in the future, if you don't have this prepared, it could also backfire on you because you didn't have it prepared. You didn't determine whether you're going to split or not. So the prenuptial agreements is a logical decision. Let me address Alondra as well. It's a logical decision to either put everything together 50-50, or reserving certain rights to property I had before, for instance, right? Or reserving future rights, that what we had before is from before, what's in the future is together. So it's an agreement. So until then, everything is 50-50. Okay? You want to keep this separate, then don't let the other party enter those properties and maintain the property in any way, shape, or form. You want to keep these properties, make sure you can prove that the income that comes from this property pays itself, and that your marital income does not go towards this property. You got it? The moment your shared income touches a property that was before you, right? Before the marriage, the moment it touches, it belongs to both. The other party has a claim. Okay? Without further fights, I'll tell you right now, I have a friend of mine that just sent me a message the other day, and she says, the attorney you got me is good. I was not going to get anything. I got 30% out of it. She could have gone any further and get more, but she got 30% of properties that she never touched. I think she went there. She was saying that she went there once or twice to clean them or help fix something or whatever. The attorney got 30% out of it. Of all the guy had a lot of properties, but you know, the divorce was his fault anyway. So listen, I'm not a pro man or pro women or pro whatever. It's not. What's right is right and what's wrong is wrong. He screwed up big time, based on my understanding, and the attorney got what was coming to him, pretty much. If it was the other way around, I would have said, "Hey, she's the one that screwed up." All right, that's how it is. Okay. Do you get to choose what properties you share with your spouse, or does everything? Felix is what I was saying before. It's usually automatic, but it could be by agreement, and that depends on your state laws on what you should do or not do. Okay. Some state laws might say whatever was before is yours, whatever's together now is ours. State of New Jersey, for instance, to give you an idea, as May 28, 1980, there's no more dower and courtesy. So that means we only own whatever we purchase together. Or the marital home, so where we live. If it's your property, it still belongs to both because it's where we live. Okay? But if something you acquired after or before or by yourself during the marriage, it's under your name only, it's your property. Just make sure, again, as I said, oh, hold on, don't get too happy. Just make sure, again, as I said, there must be no contribution to that property. The worst attorney in the world is going to be able to claim something to the property. If I went there to clean the stairs one day, I put work into it. I have what's called sweat equity. Boom. If you took money out of our bank account, our marital income, to fix something in that property, I have equitable interest or equitable title in the property. You guys got it? We covered it before. There's legal title, equitable title. Equitable title is based on monies or work performed in the property. Okay? Legal title is who's on record. Right here, make a corporation is the other way to protect the properties. When it comes to marriage, maybe not. So corporations are great to separate liability, but they might not be enough to separate the marriage or benefits in the marriage or rights in the marriage. Might not be enough, because if you have a corporation, then you own shares, right? The shares belong to who? 50-50. So whether the corporation owns property or not, right, that's a corporation. You own stock, and stock belongs to both, or could belong to both, based on the conditions I told you. Anyway, we're going to go into a break, because that's not what this chapter was about. Everybody here trying to figure out, well, how can I own something without having to pay her or pay him? Unbelievable. Terrible. All right, so we're going to go into a break, and when we come back, we're going to go into wills. All right, guys, it's 11:42. We're going to be back by 11:50. All right, so you got 8 minutes. Go get your coffee, go get your tea, go get your water, go jump up and down, get the blood flowing. All right, careful with the masks, and we'll be right back. See you in a bit.